joining us for today's tea time treat on honour-based abuse. We don't normally hold these on a Friday, and the reason we are today is that today is the National Day of Memory for victims of honour-based abuse in the UK. The date was chosen with the day of birth of one victim, Shafilea Ahmed, who's on the she's in the middle there, who was murdered at age 17 in 2003. If my maths is correct, today would have been her 37th birthday. Shafilea had ambitions to join our profession and to be a solicitor, and it seemed a fitting memorial to her for our legal community today to mark the day by highlighting and learning about honour-based abuse. You will have noted that Kerith, Andrew and I are all white, and we're very clear that we're not experts on honour-based abuse or here to impart expertise that we don't have. We're keen to learn, and we see this as an interactive experience. In preparing for today, we've read books and articles and watched presentations by many brave and strong women who have experienced honour-based abuse in their lives and communities, and we've drawn very heavily on their experiences and on their expertise. Some of the reference materials are included in the handout, and we strongly recommend reading and watching these inspirational women. And there's one man on there, Cerys Sayer, who was the Chief Crown Prosecutor for the North East and the CPS lead on this issue. And he was in quite a few videos, and his book is also worth reading. I think we all have our own personal videos, etc., and books that we recommend, and we're happy to talk about that afterwards. But they're all brilliant and definitely worth exploring. So setting out how this tea time treat will take shape, many of you will have heard of Karma Nirvana, the leading UK charity in this field, and we're very lucky and incredibly grateful to them for providing a short video presentation, and we'll start with that. Another victim of honour-based abuse is Banaz Mahmood, who we see again on the screen, who lived in the London Borough of Merton and was murdered in 2006. Hers is a horrifying story of multiple failings by many agencies. Her murder, like Shafelea's, could and should have been prevented. Andrew was on the Merton Council and was the ex-chair, apologies, the ex-leader of the council, and he chaired the borough review of her murder. So he's going to talk to us about that after we hear from Karma Nirvana and tell us what went wrong and what we can learn. After Andrew, I'm going to talk a little bit about what honour-based abuse is, who is affected, and what legal remedies we have at our disposal. It is a Friday afternoon after a long week, so don't worry, I won't be going into great detail on the law. There are links on the handouts to the key legislation, guidance and some case law. Finally, Cerys will talk about how to manage a case where honour-based abuse is an issue, with pointers and tips on how to get the best evidence to prosecute your case and tracks to avoid. And hopefully at the end there'll be some time for discussion on the issues, both within this room, but also upstairs, where we hope you can join us for drinks and a few more snacks and a bit of a more informal chat. So Stuart, if we could watch the Karma Nirvana video, please.
Good afternoon. My name is Natasha Ratu and I represent the national charity Karma Nirvana. I'd like to start by thanking Westgate Chambers for this opportunity to come and talk about the work of Karma Nirvana and to talk to you, our audience, about the work that we are doing across the UK to tackle honour-based abuse. I recall around a decade ago coming to Westgate Chambers to talk about these issues, so I'm really pleased that we've been invited back to come and tell you a little bit more about the work that we've progressed since then and to think about what work we all need to continue doing in this space. Before I get into content, I just want to start by apologising for not being able to be there in person. If I could, I absolutely would, but today Karma Nirvana are holding we're holding our 9th Day of Memory conference in person in Leeds, and this year marks 30 years of Karma Nirvana, so we're having quite a big event in Leeds to mark this really important day. The Day of Memory is one of the most important days in our calendar because it marks a collective opportunity to remember all of those that we have lost to honour-based abuse, and it also provides an opportunity to bring partners together, to bring practitioners together, to really refocus on our drive and our energy in this space, and to think about the vital work that we are yet to do. 9 years ago, we campaigned for this day, and we campaigned for this day to take place on the birthday of Shafilea Ahmed. 20 years ago, Shafilea was murdered by her parents in the name of honour, and her death represents a landslide of failures, a landslide of missed opportunities to protect, to safeguard some of the most vulnerable people within our society affected by honour-based abuse. We know that Shafilea, prior to her death, had reported honour-based abuse to her school, had reported abuse to police, to social care. She'd even reported to housing that she wanted refuge because she didn't want to marry. All of those opportunities represented a chance to save her life. And for us at Karma Nirvana, her death is very profound in that not only does it represent a landslide of failures, but it also represents a real variety of opportunities for learning and for change. Now, as I said earlier on, this year marks 20 years since Shafilea died, and this poses a really important question. Well, 20 years ago, what has changed today? You know, how much have we progressed in this space? The sad reality is that actually progress in this space has been very piecemeal and very slow. This year, we heard about the death of a young woman called Sayer in Bradford. Now, Sayer, a few years prior to her death, had reported that she was going to be forced to marry by her father, and a forced marriage protection order was taken out to protect her. This year, we saw the conviction of her uncle, who was given a life sentence for her murder. And the reality is that not enough was done to protect her. A forced marriage protection order was taken out, and that forced marriage protection order did not do anything to safeguard her in her life. So what does this highlight? I think what this highlights, we're talking 20 years ago, we're talking about a conviction this year, it highlights that there is still so much work that needs to be done. So let's start by thinking about actually, well, what is honour-based abuse? Because surely in order to understand how we progress work in this space, we've got to understand what it is. So the term honour-based abuse is used internationally to describe abuse that's carried out to protect or defend the honour of the family and or community. Now, victims of honour-based abuse, and we hear this through our work time and time again, are expected to live their lives according to honour-related norms. And in this space, what this means is that many people experience honour-based oppression, where actually they don't even do anything that goes against the expected norms because they don't recognise that what they're experiencing is often synonymous with coercive control and abuse. There are so many different potential expectations that we hear about through our helpline. So Karma Nirvana deliver a national helpline commissioned by the Home Office for victims of honour-based abuse. And we hear subjectively from individual to individual lots of different expectations that are placed on individuals. But just to share with you some of the common expectations that we hear things such as expectations for people to agree to marriage proposals, even if they don't want to marry, for them to not have relationships prior to marriage, to not have sex prior to marriage. There could even be expectations that they have to be straight, or that they have to study particular courses to kind of continue particular professions. It could be that they have to be dutiful, they have to listen to everything that they are told by parents, by relatives or spouses. And where a person doesn't uphold these expectations and they don't uphold these norms that are placed upon them, and where a perpetrator feels like they are losing that control, that victim may then be punished on account of that. And this could be through a perpetrator imposing further control methods to limit their life, to put pressure on them to comply, but it could also be through physical punishment. And this is where a perpetrator is carrying out a punishment with an aim to regain that control and to uphold that honour, and sometimes to also save face that is perceived as being lost if that victim is perceived as dishonouring themselves, dishonouring the family, dishonouring the community. Another real recognised enabler to honour-based abuse is this concept of shame, because shame prevents a person from feeling able to talk, from feeling able to talk about and disclose abuse because of the perceived stigma and the fear that if they do that, they will be bringing shame by speaking out. In the last year alone, our national helpline has responded to 9,616 contacts from the UK alone, and we recognise that this is just the tip of the iceberg. Honour-based abuse is massively underreported. We know again statistically that there are 12 to 15 honour killings that take place in the UK every year, but again, this doesn't really represent the reality as to how many people are dying at the hands of honour-based abuse. So with this in mind, it's really important on this important day of memory to reflect on what can be done to prevent honour-based abuse, because we know, despite a heightened profile of talking about this issue for decades, we're still no closer to eradicating it. Let alone eradicating it, we're no closer to really understanding the true scope, scale and prevalence of it within the UK. Honour-based abuse remains a real invisible but thriving hidden harm, and it is for this reason that today Karma Nirvana are taking action through launching a national new definition for honour-based abuse, because it may shock our audience to learn that there is no statutory definition, no government definition for what honour-based abuse is. And we feel really strongly that our government cannot begin to respond to an issue unless they properly define it. We recognise through our work that until a definition is put onto the statute books, until it's properly reflected in government language, this issue is going to continue being misunderstood, underrepresented and inadequately resourced, meaning that victims and survivors will not be getting the support that they need, that their experiences are not reflected authentically, and we're just totally missing the mark on making people safe. Victims and survivors deserve better, and the definition that Karma Nirvana have co-created with survivors puts their voice at the heart and centre of understanding this type of abuse. We're really encouraging our partners on this call today, we're really encouraging government to adopt this definition, because without that definition, without a statutory definition to frame this abuse, we're going to continue to miss opportunities, we're going to continue to miss spotting the signs, and we're not going to be able to prevent potential fatalities. I'd like to end by thanking you all for listening to my presentation and ask if you'd like to know more about the work of Karma Nirvana, including the work on our definition, including about our helpline, any data or statistics. Please do get in touch by visiting our website, which is www.karmanirvana.org.uk, and you can get further details for how to get in touch. So I'd like to thank you again for listening, and again thank Westgate Chambers for this really, really important opportunity to talk about our work.
So I think our definition is with your papers of Karma Nirvana that they're promoting today. So they've put it together in consultation, and that there is that need for the statutory definition. I'm really here to talk about my personal experience on a local authority partnership review to the death of Asma Mahmood. She was an innocent young woman born in 1985 in Iraq, who was tragically murdered in Mitcham, in London Borough of Merton, at the start of 2006. A few weeks later, her body was found in a suitcase, buried in a back garden in Birmingham. Because I was a councillor, indeed still am a councillor in Merton, in 2008-9, which is a couple of years later, I was asked to chair a partnership review of the matter with a view to learning and applying lessons. And reviewing members included the local authority, the police and the health authority. It was a confidential review and it's still not been published. But I think lessons have been learned from it, but not without some difficulty, as I will explain. But Anas was murdered by her family because they considered she had brought dishonour upon them. The family had come from Iraq in about 1995, and they were part of the Kurdish community. the cultural traditions, including female genital mutilation. Bernaz and at least 3 of her sisters were subject to genital mutilation by their father using a knife in the family home. Along with her sisters, her life was highly constrained. They didn't have friends outside of the family. In effect, the women in the family were treated as property. They were socially isolated. What appeared to matter most was the social standing of the men in the community. Bernaz commented at one point to a police officer that the approach was like something from 50 years ago. At the age of 16, Bernaz's father introduced her to an older man from the same Kurdish community who she'd never met before, and with whom he'd already done a deal. She was to marry him. And she was married, and she was taken to her husband's family. I think that was in Birmingham at the time. She had no family around her, no one to help. He felt he could do anything with her as he preferred. He would abuse her and degrade her. She had to do anything he asked her to do, such as cleaning. And she was used his name. He felt this was wrong in front of guests. So after the guests had left, he threatened to kill her. Said, if you use my name again, I will put a knife in your chest, wherever you are, even in front of the guests. She was beaten regularly, her body would receive bruises, and she was kicked repeatedly in the head, so that she found it difficult to maintain memory on issues, and he would break them. When Bernaz told her sisters how she was treated, they spoke to, that is, the family spoke to her husband. She had left her husband several times and went back to her parents, but they didn't provide protection. When spoken to, he admitted to her family that he did beat their daughter because she was disrespectful. And he did force her to have sex, but only when she said no. And that was an explanation the family found to be an acceptable explanation. And they sent her back to her husband to try harder to be a good wife. And it was recorded that Bernaz's father thought very highly of her husband, Ali Babasi, describing him as the David Beckham of son-in-laws. And it was always the men, in particular Bernaz's family, her uncle Ari, who would get together and make decisions. Bernaz later commented in a police interview that she was brainwashed into how she would bring shame on the family if she got separated or divorced. And she also commented that she had no other choice than to go back to her husband. But she eventually felt she could stand it no more and told her mother that she wanted a divorce. She left her husband and consequently was considered to have brought shame on the family both in the UK and Iraq. And it was the case that the young men in the community regularly monitored the way women behaved, what they wore, what they were doing, what they were seen doing, how they dressed. They report back. And the women had to conform to the cultural norms. If they didn't, they felt out of favour. And this is certainly what happened to Bernaz. And it was believed that allowing women and girls their own choices would diminish their honour. Now, Bernaz met a young man called Ramaz and fell in love. And dozens of loving texts were discovered between Bernaz and Ramaz. At that time, Bernaz felt she was being followed in the streets by a man she knew vaguely from family events. Because of being followed, she went to the police, and there is in fact a full police video interview in which she outlined her concerns. A man she didn't know had suggested that she get into his car for a lift, and she refused. She referred the police to the police officer in the interview to people following her. That is the main reason, she said, that she comes to the police station. She said, in the future, or at any time, if anything happens to me, in the future, it is them. The police officer's response is that if she ever was worried for her own safety, she must contact them straight away. The police officer said, I don't want you worrying. We can get somebody out to help. But as said to the police officer, now I have given this statement, what can you do for me? And the police officer responded, "You have given us lines of inquiry. We will have to follow them." Now, by going to the police, Benas was putting himself at great risk. But a police complaints inquiry later found no evidence that the police had made any effort at all to trace her husband or to investigate the case. Indeed, it took them 3 months just to write up a statement. And there were 5 occasions in all in which Benas went to the police. And there were police mistakes resulting from lack of understanding and awareness, and generally poor policing. In reality, she died without having to seek any help at all. At one point, she attended Mitcham Police Station and spoke to 2 sergeants at the desk and wrote them a letter identifying the people who she believed were trying to kill her. Nothing was done to investigate those concerns. The people she identified in advance of her murder were later convicted of it. The next event was that Benas kept a relationship with Rama secret. But she was seen by some young man in the community kissing Rama outside Morton Underground Station. And he reported this back to Uncle Eric. And there then was gathered what the investigative police officer later called a council of war at the home of Uncle Eric Mahmood, to which the men of the extended family were invited. A decision was made there and then, orchestrated by the uncle, who told the younger members of the community, "What I want you to do is kill Benas." This was a conspiracy to murder. The family was large and interdependent, and the police officer investigating later assessed that about 50 members of the family were engaged in some way in the killing. Benas was tricked on New Year's Eve to go to her grandmother's house in Wimbledon. Her father got her to carry a suitcase into the house, and he forced his daughter, who was a Muslim, to drink brandy. She was told to sit on the sofa and look at the television, but she did turn around and saw him coming up to grab at her, wearing rubber gloves and trainers. He told her to lie down because she would soon feel sleepy. But she was aware in that instant she was going to be killed. She ran and managed to escape from the back of the house and plunged her hand through a neighbour's window to try and get her attention. She climbed over a fence and staggered up the road in bare feet, bleeding from her wrists, and collapsed in a nearby cafe. Hospital staff who dealt with her considered they'd never seen anyone so frightened. She contacted her boyfriend Ramat, who visited the hospital, and recorded what she had said had happened as she was lying on a hospital trolley on his mobile phone. It's all accessible on the internet. A woman police officer attended the hospital and disbelieved her completely. She said she believed it was a girl who had drunk too much and thought she would be in trouble and was making up the story. This same officer then informed Benas's father that she had raised a complaint against him. And the police went to her home to interview her in front of her family to take a statement about the allegation. I think she even threatened at one point to arrest her for criminal damage to the neighbour's window. It's difficult to imagine a more colossal and dangerous police misjudgment. A CPS prosecutor later described the actions of the police as a failure of education and training. Yet, even when the police officer later gave evidence in court in the murder trial, she was determined to stick by her original accounts and wouldn't admit to getting it wrong. When Benas left hospital, she went to stay with her boyfriend, but was persuaded by her family to meet them in Tooting in the past. And then persuaded to return to her family at home. Benas had said to someone at about that time, "If I run away, I'm dead. If I go home, I'm dead." Ramat reported her missing on the 25th of January 2006. The chief inspector in Merton was worried about this particular missing person, then contacted Detective Chief Inspector Carolyn Good, who investigated the missing Benas and later her murder. she, in fact, you could describe her whole investigation as superb. This woman was completely focused on getting justice for Banaz. Now, with the exception of Banaz's sister, Beckel, whom the family had previously tried to kill and was estranged, not a single member of the Kurdish community gave any information or assistance. According to Chief Inspector Good, there must have been dozens, if not hundreds of people who knew what happened to Banaz. And the police faced a wide-scale attempt to pervert the course of justice, including young men making false statements saying Banaz was still alive. There were lots of red herrings. DCI Good believed that by making false statements, these witnesses were seeking to enhance their prestige in their community. Her family showed no interest in finding Banaz, even when the waterways near to her house were being dredged. Every photograph and evidence of Banaz's existence had been removed from the family. But immediate support was given to the investigation by Beckel. Saying she'd been estranged by the family, and she later very bravely gave evidence in court against the family. It transpired through the investigation that Banaz's parents deliberately had left the house and 3 of Banaz's cousins had entered, and they had brutally raped and murdered her. They stuffed her in a suitcase. The body was then taken to Birmingham. Those who were directly involved in the murder seemed, by their responses, to have enjoyed the whole experience. And they were proud of what they'd done. When 2 of them later fled to Iraq, they boasted about it. One of them at the time was staying with his brother, who was a senior Iraqi police officer. But DCI Good was on the case, and she achieved convictions for murder against Banaz's father, Uncle Harry, and a cousin. And she later pursued the 2 missing cousins to Iraq. They were arrested and extradited to England and convicted of murder. Now, the confidential partnership review I was asked to chair was required to act in a consensual manner. The report has to be agreed by all participants, including the police. It was not supposed to be investigating the murder because there were still these 2 outstanding alleged murderers in Iraq, but it was intended to draw lessons from what was already known. We prepared to carry out our work by commissioning training from the Southall Black Sisters, who were very informative indeed, particularly on the hidden extent of honour-based abuse. And I also met with Beckel at a secret location to hear her views. What I had not anticipated was the attitude and approach that the police officer assigned to the review. I can honestly say that in 35 years legal practice and encounters with the police at every level, and as a counsellor I've met very senior police officers in the Met, I've never met a police officer so aggressive or obstructive. The approach of this officer was solely concerned with avoiding any blame whatsoever attaching to the police, and was clearly not concerned with any constructive lessons that could be drawn. So the lessons we drew were primarily with participants in local authority and health authority, with minimal contribution from the police. And it was apparent, though, that signs of abuse had been missed by agencies over many years. When I met with Beckel, she was angry about what had happened, obviously what happened to her sister, but also what the authorities hadn't done to support Banaz, Beckel, and the youngest sisters in the family. Like Banaz, a younger sister, Paisley, had been married at 16 in a forced marriage. To be married, they had to be presented by the family to the marriage registrar. No questions were asked by the registrar about this ceremony. No questions were asked by their school about these girls being married at 16. Neither had been able to face having a baby in the context of the forced marriage and the abuse that they were receiving. So both had had terminations. Naturally, they met medical staff in the context of those terminations. No issues were raised or pursued. And as we heard, Bernaz encountered hospital staff when she stayed from her grandmother's home. So many missed opportunities, and of course, not least by the police, to actually step in and to assist Bernaz. So our recommendations focused on training and awareness of frontline staff in social services, in the NHS and schools. I inquired today in the Safer Merton staff, as they're now called, and I was told that the recommendations have helped shape how cases and work across the partnership by agencies is delivered. Merton now has a MARAC, which obviously is common usage across the country. Vital to have these multi-agency risk assessment conferences, which I don't think existed at the time of Bernaz's murder. Also, locally in Merton, an independent domestic violence advocacy service was set up. I think possibly as a result of the recommendations. I don't suggest the MARAC was a result of the recommendations that we made. There have been national changes to police procedures that have to do with honour-based violence. And in the local authority in Merton, they received training from an organisation called ICRO, IKWRO, which is a registered charity that provides advice and support to Middle Eastern and North African and Afghan women and girls living in the UK who have experienced or are at risk of all forms of honour-based abuse, including forced marriage, child marriage, and female genital mutilation or domestic abuse. Thinking back now, the case was an eye-opener to me on how extensive honour-based abuse was. We certainly learned that from the sample of assistance. The large number of cases they hear about, and there are at least a dozen murders every year, but probably rather more. And a lot of these murders take place abroad. People are lured to other countries and killed. I also learned how isolated and bullied on the basis of victim environment. Your first reference point, you're under attack, to your family. The contact in these cases of family of the perpetrator. And they often almost terribly kept in kind of isolation in society. Vanessa's sisters and herself did not have friends at school because of the way in which they were supervised by their family. It's sometimes said that agencies don't intervene because they are separate from cultural traditions of ethnic communities. But no, there's no cultural tradition in justify abuse or violence. Or agencies holding back from investigating it. And the enduring lesson for me must surely be that protecting the human rights of vulnerable victims must be always prioritized. And we must act whenever we see signs of weakness. Okay, so those are my thoughts in relation to Bernaz moment. I rewatched the programmes, Bernaz, a love story, and also directed to a very good TED talk by her sister, Paisley. And these are emotional watches for both of them, watching.
There are links to those on that handout, the resources handout, which I think you're also going to get by email. And there's a lot of stuff on YouTube, but there's two, the Commemorative Love Story won awards. There are a couple of TED talks, one's by the founder of Karma Nirvana, and they're definitely worth watching. They are powerful. And just picking up on the days, one thing that if you read the books by women who have had experiences of honour-based abuse or watch the videos, time and time again they will say that one of the issues is that the People who are trying not to be racist don't intervene because they don't want to be seen to be racist, and that leaves people at risk. So it's an area which needs a lot of sensitivity, and you need to listen to the voices of the victims and their communities. But one of the problems has been that either a lack of interest to find out issues or to see them and deal with them, but also just being anxious about being seen to be racist, and it's something we have to guard against. So we heard from Natasha that there is a statutory definition, and even the term itself is controversial. Some prefer to use the term so-called honour abuse. Some will put inverted commas around honour. Some will talk about harmful traditional practices, and on that there's again a book in the resources handout which will catch a tune of harmful traditional practices. It's absolutely fantastic in terms of information about various practices, resources, where to go. It's really fantastic. A lot of good stats in here. I've drawn it heavily. The most commonly used term is honour-based abuse, so that's what we'll use today. Now again, as Natasha and Andrew have focused on, Karma Nirvana is pushing and campaigning for a definition, and you've got it in your handout, special one on that. It's one we agree with and would commend. It's very comprehensive. We have to wait and see if it gets adopted. Not only, well, no statutory definition of honour-based abuse. Within Practice Direction 12J of the Family Proceedings Rules, it also doesn't define honour-based abuse. It defines coercion and all those matters. But there's just a little footnote to say that honour-based violence, which was the older term, and then separately it refers to forced marriage, female genital mutilation, come within the definition of domestic abuse. So very much sidelined. The CPS and the UK National Police Chiefs Council, the definition that they use, and therefore the one that we're most likely to come across if we're in cases where there has been any criminal prosecutions, etc., is an incident or crime involving violence, threats of violence, intimidation, coercion, or abuse, including psychological, physical, sexual, financial, or emotional abuse, which has or may have been committed to protect or defend the honour of an individual, family, and/or community, for alleged or perceived breaches of the family and/or community's code of behaviour. It includes a wide range of behaviours from murder, female genital mutilation, forced marriage, kidnapping and false imprisonment, at one end of the scale, through to the more common, but nonetheless very harmful forms of abuse we're all very familiar with in our practices of physical, sexual, emotional, financial abuse, stalking, harassment, again we heard about that in Vanessa's story, and coercive control. It can lead to self-harm and it can lead to suicide. Shafilea, for example, was drugged and taken to Pakistan for a forced marriage. To escape that, she ingested bleach, leading to her hospitalisation, first of all in Pakistan and then in the UK. Honour-based abuse is possible within any culture, nation, community or group that values honour and whose individuals respond to challenges or losses of honour. And again, loss of honour is what led to, or trying to regain lost honour is what triggered Vanessa's forced marriage. And they respond with abuse or violence. At this stage in history and within this jurisdiction, it's primarily an issue with communities originating from Africa, the Middle East and parts of Asia. But other communities in the UK are also impacted. The Orthodox Jewish community and the traveller community are also communities with issues of honour-based abuse. At other times in history and in other countries, honour-based abuse has impacted different communities. It's not so long ago that unmarried pregnant women and girls in Ireland were forcibly put in Magdalene homes, treated abysmally during their pregnancies, and then had their babies removed and adopted without their consent. That would be an example of honour-based abuse. Importantly, honour-based abuse is not supported or condoned by any major religion. The majority of victims are female, but there are male victims as well, often abused as a result of their sexuality or gender identity, or because they are not seen to be protecting their families or the community's honour. In 2021, 26% of cases where the forced marriage unit provided advice or support had male victims. We don't know how many victims there are of honour-based abuse in the UK, and that's for a number of reasons. The government hasn't been very proactive in seeking data, and many crimes are not reported. Victims may not report. South All Black Sisters research tells us that South Asian women are 3 times less likely to report abuse because of issues relating to honour and shame. Research by Safe Lives has found that victims of honour-based abuse will experience abuse for at least 5 years before reporting. That's 2 years longer than for victims of domestic abuse. Given that the BMA estimates that in general, victims of domestic abuse may experience 35 incidents before taking action, there is a huge hidden issue with victims of honour-based violence, honour-based abuse not being protected. Another reason for low reporting, and again, Andrew has touched on this, is that unlike domestic abuse, where there's usually a single perpetrator, and so likely that a family member will report if somebody goes missing, or they'll report their own concerns about the experiences of that person. The family and or community nature of honour-based abuse means that it doesn't happen in the same way. So looking at Shafelea's case, both her parents were involved in murdering her. So neither, of course, reported her missing. Her murder was only discovered when her body was. Victims of honour-based abuse are 7 times more likely to experience abuse from multiple perpetrators, including parents, grandparents, siblings, extended family, and members of their community. Nazir Afzal said that it was a crime that would often be investigated in the way that they would do organised crime. These are planned, multiple perpetrator crimes, and they need to be looked at in a different way than domestic abuse. That has implications for how we manage these cases in our practice, which Cerys, I think, is going to touch on later. The extended family and or community nature of honour-based abuse means that there are no easy answers for victims. Unlike leaving a domestic abuse relationship, where it's likely that a victim will be able to maintain relationships with family and friends, in this context, where literally life may be at risk, it means cutting off contact with family and with community. It can mean moving to an area you don't know, because that's where you may be safe, and where there are no family or community links, which is isolating and may expose victims to other forms of abuse, such as racist abuse. And that's been the experience of women who have taken that step. Many go back even when they know the risks they carry, and it's easy to see why that may be tempting. And again, we've heard Banaz's comments of, if I run away, I'm dead. If I go home, I'm dead. So it's very easy to want to swoop in and help. But our key tools for addressing 2 of the main planks of honour-based abuse, forced marriage and female genital mutilation, can result not only in protecting them from these terrible abuses, but also in restricting the lives and the freedoms of those we're trying to protect. And not just when they're children. Sometimes these restrictions and interferences, which may be unwanted by the victims, are open-ended and potentially lifelong. So just to give 2 examples, and they're both within the handouts. In Re-K, which is a 2020 case, so very recent, a forced marriage protection order was made on the application of the police to protect a 35-year-old woman with capacity. As part of the order, her passport and travel documents had to be handed to the police, and there was a prohibition on any application for replacements. Kay wanted the order discharged. The court refused that, and the order was not time limited, although the Court of Appeal subsequently did provide for a review. The order prevented Kay from leaving the jurisdiction, and the consequence of this was that she was unable to attend her mother's funeral in Pakistan. At least 3 of the 4 judges involved in her case, I suspect all of them, I haven't been able to find out that the last one, were white, and 3 of them were male. So on top of the complexities of competing European Convention of Human Rights, Articles 3 and 8, added to the mix is the UK's long history of a paternalistic approach towards non-white communities and towards women, which is something we need to watch for in this. In a local authority versus M&M 2018 case regarding an application for a female genital mutilation protection order, the court made an order in respect of an infant girl. Her parents had been in a relationship for 10 years, and she was the youngest child and only daughter. Before her birth, the family travelled from London for a holiday, but ended up in Sudan, which is where they'd originally come from, with what appeared to be a plan by the father or extended family on the paternal side for the family to relocate there. Em returned to the UK to give birth, and she reported the risk of FGM to the local authority and sought help. The local authority applied for an order, which was granted, and which prevented Em's daughter from leaving the jurisdiction. So Em and her daughter were in the UK, and her sons were in Sudan. Em sought discharge of the order and began to minimise the risks to her daughter. The court accepted that Em herself was opposed to the practice of FGM and found that she was highly motivated to protect her daughter from this. However, the court also found that she would not be able to protect her child from the risk of the extended family or the community if the order did not remain in place, and she was not successful in overturning it. The effect is that Em cannot have a full relationship with her father, or her brothers, and M, who cannot countenance travelling alone and leaving N in the UK, is unable to enjoy a full family life with her partner and her sons. This isn't to say the order isn't necessary, but I'm simply flagging up that each case carries a high price for the victims it seeks to protect. So the remedies. First and foremost, the remedies we already know and love: non-molestation orders, domestic violence protection orders, injunctions under the Protection from Harassment Act, the usual gamut of protection support we use to protect against domestic abuse. Care orders can be used in so inappropriate cases can the inherent jurisdiction, I'm struggling to speak today, and of course Practice Direction 12J applies, and the vulnerable witnesses in terms of at court and how to manage the case there. Specific to honour-based abuse are forced marriage protection orders and female genital mutilation protection orders. FGM and forced marriage are both criminalised in the UK. If that sounds good, don't get overexcited. You've heard Natasha refer to Samaya Begum, who was murdered last June by her uncle after she refused to marry despite the forced marriage protection order being in place. Her uncle was convicted and sentenced earlier this year. The judge rejected the prosecution's request that the murder be treated as any form of honour killing and said that it was pure speculation to consider whether the murder was part of a family agreement. And what he said was, it is not possible to identify a motive for this dreadful attack. We've heard Karma Nirvana, they certainly think there is one. As for FGM, this was criminalised in the UK in 1985. The first prosecution didn't take place until 2015, 30 years later. And the first, and as far as I can tell, the only conviction was in 2019. There is a positive obligation on specific professionals, including healthcare professionals, teachers and social workers, to report to the police if they discover through the course of their work that an offence of FGM appears to have been carried out. In the period July to September 2021, there were over 1,500 women and girls that had healthcare attendance where FGM was reported. And of those, 665 were new recordings. So there's a huge disconnect between the numbers of apparent FGM offences and the numbers of prosecutions, let alone convictions. 2011 research by City University has found that even as long ago as that, not one local authority is not impacted by FGM as an issue. So in my view, it would be wholly misleading for us to ask potential victims to put their full trust into the legal process, because we still have a very, very long way to go. Forced marriage protection orders were inserted into the Family Law Act in 1996 and in 2007, and they've been enforced since 2008. And there's a bigger handout which sets out the primary provisions of those, and it also includes the female genital mutilation protection orders, which were included in the Female Genital Mutilation Act. And they came into force in 2015. And also there's a big chunk from the case of repay in that, because that's quite a key case. There are huge and intentional similarities in the way that these two provisions are set out in legislation and how the courts approach them. They're both civil orders and breaches a criminal offence. The applications can be made as of right by a potential victim and by what's defined as a relevant third party. That's basically a local authority. Anyone else is entitled to apply, but they need the leave of court, and generally that seems to be the case. The terms of the orders, and I find the wording clunky, but they can cover conduct outside the jurisdiction as well as or instead of conduct within the jurisdiction. They include respondents who are or may become involved in other respects, as well as or instead of respondents who commit or attempt to commit the acts that the two different pieces of legislation seek to protect from. And they can relate to other persons who are or may become involved in other respects, as well as respondents of any kind. Involved in is not specifically defined, but both provisions state that examples include aiding, abetting, counselling, procuring, encouraging or assisting, and also conspiring. Both provisions protect not just a potential victim, but somebody who has already experienced either forced marriage or female genital mutilation. So the provisions are very broad in scope and intentionally. So they cover not just actions within the UK, but overseas. One of the differences who the acts apply to. So a forced marriage protection order can be made to protect any person. Female Genital Mutilation Act covers, the Act refers consistently to girls. The definitions within the Act make it clear that girls include women. It is, I think, unfortunate to say the least that the amendment didn't simply replace girls with females or add women in there. It seems somewhat paternalistic, but there we go. When considering whether to make an order, court in both cases must have regard to all the circumstances, including the need to secure the health, safety and well-being of the person to be protected. In the case of a forced marriage protection order, the court must also have regard to that person's wishes and feelings so far as they are reasonably ascertainable and as the court considers appropriate in the light of the person's age and understanding. As we've seen from K, even for an adult with capacity, their wishes and feelings may carry little weight. The court will carry out a 4-stage test. They'll establish the underlying facts, then determine whether the need to protect a person from the perceived harm has been established. The third stage is an assessment of the risk and of the protective factors relating to the particular circumstances of that case, with express consideration of whether there is a real and immediate risk of breach of Article 3 rights of torture, inhuman, degrading treatment. If the Article 3 threshold is crossed, then the court will have to achieve, and this is the wording in the UK, an accommodation between the necessity of protecting against that harm and the need to respect the individual's Article 8 rights. That's the meat, I think, of any application. Not only will it impact on the protected individual's rights and freedoms going forward, as we've seen in the 2 cases we've looked at, there may also be a risk that it may deter potential applicants wanting protection but concerned that the price is high if they know other people who can't go to a parent's funeral. The wording in terms of what the order can do is in both cases vague, and again that's intentionally so. The orders may contain such prohibitions, restrictions or requirements in such other terms as the court considers appropriate for the purposes of the order. And that means that the court can be flexible and practitioners imaginative in respect of what specific terms may be necessary in that case to provide adequate protection. And in K, what we've been told is that this is not an area for template orders. Each case must be considered carefully and bespoke provision found. Provisions often include a prohibition on travel, holding travel documents. That can create its own problems because often that's an important form of an identity document, exclusion zones to cover someone's home, school if they're younger, as well as the obvious prohibitions on allowing, attempting, etc., to commit the acts that the substantive acts that the provision is seeking to protect from, so not to allow a forced marriage or take any steps towards it, for example. And the court must consider each and every proposed term carefully to consider if it's necessary and proportionate. In K, Southall Black Sisters said there is a fine line between protection and excessive intervention. One final point, because I thought it was quite interesting, in relation to the Female Genital Mutilation Act, is that it is an offence under the Female Genital Mutilation Act to fail to protect a girl from FGM. And the offence is committed by a person who is responsible for such a girl, either by way of having PR for them and frequent contact, or if the person is aged over 18 and has assumed responsibility for the girl in the manner of a parent. There are defences to it, it's not a strict liability offence. But I think the question it raises, and I don't have an answer, is whether a local authority could be liable if a child looked after or to be subject to FGM. And it's particularly important with older teenagers where perhaps they're absconding, etc., or we've all seen cases before where the level of supervision is not what it should be. So that's a short overview of the issues and the main legal remedies. And now it's over to Cerys for the tips and tracks of running a case where honour-based abuse is an issue.
Thank you, Linda. I'm going to try and draw matters together now in a helpful way, having heard the really interesting and personal views that Andrew was able to bring to the discussion, and obviously the legal overview that we just helpfully heard from Linda. I can only echo what's been said about the talk given by Paisley Mahmood, which is the 15-minute TED talk. Linda's put together an amazing list of resources, and that particular talk's on the very last page. It's the very last link. As I say, it's only 15 minutes, and it really does give you some insight into how powerful that particular young lady is, having been through such an ordeal as indeed the rest of her family had. She ends her talk by saying very strongly, child marriage must become a crime. And this is the last legal update therefore, because 3 years after she gave that talk and made that plea in February of this year, the Marriage and Civil Partnership Minimum Age Act 2022 came into force. And so therefore it does now read that a child aged under 18 should not marry or enter into even a civil partnership, even if they have parental consent. And anybody who causes them to enter into, as I say, civil partnership or marriage, in fact, commits a crime by doing so. And that crime is now punishable by up to 7 years imprisonment. Previously, it was illegal and a criminal offence to, for example, coerce or threaten somebody to enter into a forced marriage. So that there is a higher bar now, a wider legislative protection there, because as I say, it's simply by permitting it to happen and by not protecting them, similarly to what Linda just explained there in relation to FGM. So it's probably something that I'm sure Casey is very happy about. Indeed, fittingly, we heard from Natasha Ratu at the beginning of the talk, as you saw in her video. She's a member of Girls Not Brides Coalition. There's a link to them in the resources as well, but it was in fact them together with Pauline Latham, an MP, who drove a campaign so that that legislation was pushed through Parliament. And what Natasha Ratu has to say about that is that the change to this legislation on child marriage is a huge victory for survivors, is a huge leap forward to tackling this usually hidden abuse, and will provide a great degree of protection to those at risk. I tried to sum it up really in my own words and came to the one word being that essentially honour-based abuse is underground, if you like. Child marriage is pushed underground, but in fact I think the words that Natasha Ratu used in her video are probably much better, although there were more of them. Invisible, hidden, thriving harm. It describes how it is able to self-proliferate, because essentially, for example, by young girls not being able to go into education, being forced to remain at home, and in fact themselves become very young mothers. You can see how unfortunately the cycle is able to continue, and as Linda says, therefore it's very difficult for us to tackle or to know what statistically that we are dealing with. Ultimately, what Casey's sister said at the end of her talk, and again she said it very loud and clear, that she was outraged at the number of professionals who failed to help us, as in her and her sisters. She listed them as, we've already heard from Andrew from his review, and referred to them collectively as missed opportunity, but individually she named them as the nurses, the GPs, the teachers, the social workers, the imams, the registrars, and ultimately the police. Clearly lawyers were not on that list. However, we as lawyers can and do have a role to play. And in terms of looking at the cases that come to us that do have this element to them, we need to think about how best can we deal with such cases. There's no perfect checklist or template that I can give you, but we three lawyers have all come into contact with this theme in our cases, and therefore, as Linda said, some tips and tracks from those that we've experienced professionally can be summarised as follows. I've oddly recently come across this theme in financial remedy proceedings, and I'll come on to deal with that in a moment, but I am going to anonymise an ongoing case I have, which is in private children proceedings at the moment. And ultimately, I think that's probably the best example I can give you to try and harness together some of the different elements that we've discussed this evening and how you can potentially apply that then in your practice. Ultimately, I'm acting for a mother at the moment from a religious community who was forced to flee some 15 years ago. And common to what we've heard tonight, she suffered, obviously, honour-based abuse at the hands of not only her husband, but her in-laws for years and years. Ultimately resulting in house arrest, starvation. And when she was expecting her child, she did decide to flee, and she was successful in that. She did, however, have help from within the community from one person who helped her, and the police were somewhat more proactive, placing markers on where she lives now, and obviously the battery of the orders that Linda's already spoken about in terms of non-molestation orders, prohibited steps orders to protect her and her child. Ultimately, the particular difficulty in this case is that when the applicant rather first sought contact, the matter was instituted a fact find, but at that stage then the applicant father decided to abort his interest in the proceedings, and so the proceedings fell away. 10 years have now gone by, and all of a sudden the applications will come from the father for contact again. Who we are dealing with is a somewhat historic set of circumstances, more historic than you would normally, which brings with it its own complications. But I think what's clear from what's been said by Natasha Ratu about the shame and how that drives down this underground nature, if you like, of the abuse, and clearly what's been said both by Andrew and Linda about how long it takes for these issues to come to the surface sometimes. It's quite common, therefore, in these cases, no matter what the timescale is, that it's quite often a longer timescale than you would be dealing with if it's the correct terminology to say your typical domestic abuse case, because, as I said, as we all know, it takes a lot longer for people to come forward and to say what they've been suffering. So you do therefore need to think more forensically and creatively when preparing your cases, and try and think outside the box somewhat if you need to plug the gap. The particular difficulty that I had in my case recently was the fact that on review it transpired what hadn't been explored the first time around, if you like, is the fact that the wider family had kept other family members within the home, had committed similar acts against other family members, and there was an understanding that the police would be involved in releasing these people from effectively house arrest. So naturally, one thinks to apply for police disclosure. What we also know, unfortunately, from, and I say unfortunately, the Sussex Protocol that we're all familiar with, 5D states how, in fact, you shouldn't go beyond 2 years in terms of disclosure unless you can demonstrate that this is a case that warrants it, that it is exceptional. Clearly, I made the application that this was such a case and was successful in the application, and therefore had a police disclosure that went back some 15 years. Frustratingly, we still weren't successful in managing to collect together what we thought may come from that. And we are still probing now. But as I say, that gives a flavour as to the sorts of exercises that you may have to go through that you wouldn't ordinarily, or additional thoughts. And so ultimately, that brings us on to the other elements that we've also spoken about tonight, and the fact that there are then the added complexities of multiple perpetrators. So where Linda, for example, has said, use the word conspiracy, she's quite right. You have a multitude of people often involved in these cases. It's not a straightforward case of one person's word against another, as you often might have in your typical fact find. And therefore, you really do have to think about how much work that's going to create for you in terms of witness statements, who your witnesses are going to be. And in terms of how that translates in evidence, it's extremely difficult from a judicial point of view to assess when perhaps you are faced with one person who has a completely different story to a multitude of, maybe as many as I think in Andrew's case, that have hundreds of people from the community who have come together and have their cohesive story. You can imagine, from, as I say, from a judicial point of view, how difficult it might be. And indeed, the case law that Linda's provided at the bottom of page 2, and there are a number of different cases there which give you a flavour as to how differently judges have come to and dealt with this. Not necessarily always, you may not agree, with the way in which they've interpreted that evidence. and the outcome of those cases. But as I say, again, it's just food for thought. We don't have the answer, can't give a perfect template, but it is certainly something to consider when preparing statements. But I think it's right to say that the detailed narrative statements that we've now become used to preparing for controlling coercive cases are certainly the right way to begin preparing documents in cases like this, given, as I say, they're going to be very multifaceted and over a long period of time. One thing you've also got to think about is, what are the other side going to come back at you with? We probably are all familiar with DAVO, deny, attack, reverse, victim, offender. You can only imagine the claims of alienation, for example, that are going to be levelled at you when trying to say, well, this is the reason why you can't have contact. So everything, the stakes are I would say, raised effectively. And the risks that we have in typical domestic abuse cases are, again, somewhat different to honour-based violence case, honour-based abuse cases. And the reason for that is, some of you I'm sure will be aware, in the most serious typical domestic abuse cases, the professionals actually say our risk continues to escalate rather than abate. And that is the same in the cases of honour-based abuse. So as your case is going on and unfolding, even if the parties are separated, it in fact in no way means that your client's any safer. In fact, quite the opposite. And indeed, that recent case that I've just spoke to you about now, the typical example of how that mother remains absolutely petrified for his son, despite the fact that he's now a teenager. And so you really do need to remain vigilant about how you're going to manage that risk. There is a standard box of tools that we discussed earlier, Linda touched upon. But certainly we've got collectively a number of examples as to ways in which, unfortunately, there's an additional concern or complexity because of the nature of this case. Andrew, in one of his cases, and perhaps it was his review, apologies, where there was a taxi driver called to transport the victim. And then the difficulty being that the taxi driver was himself from the wider community. So rather than delivering person to a place of safety, took them back to the community rather than directly. Linda, for example, in a case concerning a mother who was trying to avoid being separated from her children by written ICO, needed to be placed in a refuge, but there wasn't a suitable refuge that had the expertise to deal with that level of risk. And indeed, I think then when one was found, that refuge was in fact too close to some of the extended family. So there were all of these extra factors to consider. And in the finance case that I had recently, we had kept addresses confidential, names confidential, and actually it wasn't until at court and suddenly faced with an interpreter who have to confess that nobody had considered in advance, where is this interpreter from, what are their links. Although they were official and they had the badge and we could do some background checks, my client was extremely nervous about what information was going to be passed back to the community that she herself had also spent some time ago. So those are all things to think about. In a different case, not an honour-based abuse case, but it's translatable, when we had a remote hearing not that long ago, excuse me, my client had gone to a place of safety, her solicitor's office, to join for the remote hearing. And in actual fact, the other side, the husband realised where she was. And because the solicitor's office is obviously highly easy to find, then made his way there and followed her home instead from the solicitor's office. So on this particular case that I have that's ongoing at the moment, and with that, having had that in mind, I was very careful about, we've only had remote hearings so far, I was very careful about where she joined from, concerned about IP address, for example, even if she wasn't at a solicitor's address, wasn't at her own address, that if this person was so inclined, they could detect where she was by that method. So she was very careful to make sure that was not an obvious link to her. And indeed the case of back and forth soon, and for the first time it will be in person. And ordinarily, if you have a vulnerable client, might meet them in chambers and walk them across to the court to try and make and help them feel more at ease. But again, given the example that I said a moment ago about the taxi driver, I don't even think that is necessarily appropriate. So that is something that I will need to reflect on, and that's probably a thoughtful point to perhaps pause, ask if anybody has any question about what we've discussed this evening, or wants to have any discussion. The idea of tonight is it's a Friday night, this is tea time training, and the fourth tea being not in their title but being treats. If anybody does want to discuss matters but would rather do so upstairs in a more relaxed environment, then we're very happy to follow on it there. If anything's cracking now, or hopefully I think that's all we can help you say on the topic for the evening.